Hey everyone, welcome to Thursday, the 4th of June already. Doggone it. So welcome to everybody. If you have not heard already or not, the Senate passed the bill last night, and there were some pleasant surprises in that I wouldn't have bet on a 24-week versus 8. I figured they would shave it back a little bit, but that's a good thing. So I'm going to go ahead and just so you guys know too, we're going to do a hard stop at noon today. So there's going to be a lot of stuff to cover. So hit the Q&A button. And if we don't get to everybody's stuff by the end of, by noon, you can hit us with FAQ@trustbgw.com. and then be back on Tuesday, because I'm sure we're going to be back on the same bat channel, given all that information that has been clarified. Also, if you're on our distribution list, you're going to get an email later on today that has a link to this recording, as well as a summary that we've put together that goes into a lot more detail on this Senate bill, which I'm, pretty sure that the president's going to sign and it's going to get moving. So Adam, you want to take it and then we'll pass it on over to Jack before we hit the questions?
Sure. Thanks, Gary. So a couple things about this. And again, it's really good news for businesses because it provided a lot of flexibility for people that I think, not necessarily sure that it negates some of the guidance we gave before, but I think that, my own feeling is that based on some interpretation that there may be some pending guidance. So as always with every caveat, this is what we think today and what we know today that could change in 24 hours or even less than that based on guidance from the Treasury. But the couple big things that changed, we went from 8 weeks. We talked about this on Tuesday, but now it's going to be law, assuming that President Trump signs it. One is, you got 24 weeks instead of 8 weeks. So that's welcome news for people that were worried about reopening based on, how their business had been impacted. That's the first big one. The second big one is that the people that were struggling to get to the 75-25 ratio on the payroll side, that's now gone to 60-40. And I'll talk a little bit about, actually, I'll go ahead and hit it now. On that piece, we had a lot of people that were struggling, because they felt like they weren't going to get to the 75% of payroll cost piece. They were struggling to say, well, can I add this in on the 25%? Can I add this in on the 25% to really get to their max forgiveness? So all that said, my feeling is that whether it's 75-25 or it's 60-40, the fact that you now have 24 weeks to deploy the money, I mean, unless somebody is really severely impacted, in which case, when I think about our client base, you'd sort of question, wow, maybe there's some bigger problems that I've got in the business that I really should be thinking about. It doesn't seem like it should really be that difficult based on the clients that I've talked to and had meetings with to get 60-40 deployed, if not the original 75-25, when given the benefit of 24 weeks instead of 8 weeks. I mean, that's 3 times the length of time. I can do basic math. So I just feel like, wow, I mean, we really shouldn't have to be scraping at the well on, our fuel costs and, can I expense my antivirus software, because it really, I think everybody should be able to hit the payroll side of this thing. So that's good news. The last one I'm going to touch on, because I want to let Jack have a moment to shine here, that I think is really important too, is that on the rehire piece, going back to making it really easy, so they still haven't changed any guidance around, hey, you have to offer a person a job and then you have to, get a written rejection from them. But implied in this law is that that's probably going to go away, because the way the law reads is, you're unable to rehire people, you're unable to refill the position, or otherwise you just don't have a dang position open anymore because your business has suffered, are all reasons that you don't have to hit the FTE count. as long as you document those. So going back to, Jack's electronic file that all of us should be making record of, if you were struggling to hit the FTE count and you're like, crap, I don't even know how I'm going to get people to give me back rejection letters. Well, you just got a gift called, pending further guidance. If you can document the fact that you are struggling to rehire back to the full complement because you've got, revenue issues, you're going to be in pretty good shape. So when I think about our construction clients who are going like gangbusters, but then are going to see some sort of a fall off probably in the fall in December, I think this is going to be potentially be, pretty good news for them. And it's also definitely going to be good news for the hospitality businesses or anybody for that matter, that's in the, hey, my folks are making more on unemployment than they are working for me game. What the heck am I supposed to do? Well, all that, just, there's still got to be guidance that comes out, but effectively all that got thrown out the window. So, big three that I'm talking about right now are, first off, 24 weeks. Second off, doesn't have to be a 75-25 ratio anymore. It can be 60-40. And third is, we just got a big flyer lie for the golfers that are out there. So, pull out the driver on the deck on the FT count, because, and if I can get in a Star Trek reference this time around, I will do. You just got to, well, actually, I will get the Star Trek reference in. It's no longer as important to replace the red shirts because you don't need that much of a crew anymore. Just kidding. That was terrible. I really tried hard on that one. So you just gotta pass on the FTE count for the most part, assuming that you can document the fact that you didn't need the positions anymore, or otherwise you made a best faith effort to rehire. You just couldn't get the position replaced for whatever reason. So with that in mind, I will turn it over to Jack.
Sure. Thank you, fellas. Yeah, so very interesting past 24, 48 hours on this program. And I was really looking for someone to put together a chart to kind of guide us through what the Paycheck Protection Program is and what people are referring to as the Flexibility Act. And so I put a chart together that is just to kind of keep things straight, but it's subject to further interpretation. So recall kind of the civics lesson that I originally got backwards the other day, which, we're at the point where House passes, Senate passes, it's on the president's desk, hopefully gets signed soon. I'm not aware of, as we speak now at 11 o'clock, whether or not it's been signed, but
it wasn't as of 15 minutes before this call. So. Okay.
All right, so a quick kind of history of what happened. So you have two representatives, one from Texas, one from Minnesota, led the charge on the Paycheck Protection Program Flexibility Act. So that's how it's going to be referred to and distinguished as from the PPP program or the PPP Act, which is really the CARES Act. There was some discussion and concern about this extension of time and what it applies to, and where they ended up with was that it's not an extension to file an original application. That is still, with the timeline that was prescribed, but it moves out other certain deadlines, as Adam has mentioned. What was interesting is that there were two holdouts. And actually 3 holdouts. It ended up being a 417-1 passing. And I say that only because there's so much partisan issues going on, whether it's in relation to, the recent death at the hands of the police officer in Minneapolis, or dealing with all kinds of other issues, that it's very interesting that the lawmakers came together almost unanimously, as closely as they could. So a few comments on some things that additional parts of this Flexibility Act. So Adam had mentioned the covered period being extended from 8 weeks to the earlier 24 weeks or December 31st. The spending thresholds, as we've been talking about, going from 75-25 to 60-40. Now, in the things that I've read, there is some discussion as to whether it is, if you don't hit that 60%, is it catastrophic to your forgiveness? Obviously, that's not the intention, but it could be interpreted that way. And so I assume, and there has to be clarification, that it still should be a pro rata. You shouldn't lose all of your forgiveness because maybe you didn't hit 60/40. Now, to Adam's point a few moments ago, you should likely be able to hit that number. And there's also commentary that a lot of your landlords and other people that were in that 25% bucket are going to be happier because now that bucket is 40%. The unforgiven loan repayment period was 2 years, and under this Flexibility Act goes to 5 years. And there's some question as to whether or not that applies to, and we think that it applies to only loans that are originated after the Flexibility Act passes, meaning not yet and until the president signs it into law. But again, subject to interpretation as to what that means. The forgiveness application timing, in the application packet, it says October 31st, and they've moved that to 10 months after the end of the cover period, or you have to start making loan payments. And there's some question as to whether that only applies to the 5-year extension for loans made after the Flexibility Act gets put into place. So a lot of moving parts. And then there's also more information. I couldn't find a whole lot of information other than the rehiring was June 30th. And now it's been moved out to the earlier 24 weeks or December 31st. And what that means is, and what I've seen is kind of definitionally that it is those that are unable to hire former employees and unable to hire similarly qualified employees, or unable to return to the same level of business activity due to compliance with health guidelines. That last part to me is new. Okay, so we start talking about, yeah, you offered not acceptance, or it was rejected, and then that doesn't count. What happens if there is a genuine good faith health issue, either on your part or your employee's part, where it just wasn't feasible for you to come back to the office? So that's an additional component. And so, you continue to read through things about, what does all this mean? And again, back to where we're at in the process, once it goes into law, then you have well, what does it all mean if it doesn't literally say that in the act? As well as, even though it says that literally in the act, what does that mean? So that's where SBA, Treasury comes in. There is some discussion, even as the Senate was passing this bill yesterday, that there would be another bill discussed and passed to further interpret the Flexibility Act. So, it's, again, we've talked about this from the beginning, baby steps, and we're at the kind of the next evolution of this. And so, that's kind of essentially what I've seen. And again, this is all new. This just happened, and it's still happening. It isn't law yet, but hopefully that will happen soon. And as Gary said, I think that BGW is going to put out some interpretation or discussion of what all that means, so that way you don't have to have been vigorously taking notes or hit the rewind button over and over again of what I just said for the last few minutes.
Yeah, that's right. So for everybody that's on the line, we've now got 104 participants. So we've added about 30 since we opened up the gate at 11. I'm going to just remind you, use the Q&A, not the chat. You can harass us on the chat, but use the Q&A for your questions. Also, we're going to do a hard stop today at noon. So we're going to try to rocket through these questions. And if we don't get through all of them, because Adam's got a celebration, he's got a son that has graduated and he needs to be with his family. So we're going to do that. And then if you do have questions that we didn't get answered, hit us with FAQ@trustbgw.com. And you can also hit me, but FAQ@trustbgw.com. And my email is gfrey@trustbgw.com. We will also be putting this thing up on YouTube, on the BGW CPA YouTube channel this afternoon. And once this is downloaded, we will include a link to that, as well as the one-page summary that Blaine Hawkins has gone through with our team and kind of done a deeper dive on what does this mean from the Senate bill. So I'm going to go ahead and lock and load on questions if you guys are okay for it. So here's the first question. What do we do if the 8-week period ends in 2 weeks and the safe harbor was extended to 12/31? Do we apply for forgiveness now? I'm asking because we're still not able to rehire in the near future.
So let me answer this question. Then also one other thing that the bill was silent on, and then some speculation that I'll hop on at the end. I think, our take on it right now is that, you can still apply for forgiveness under the old application process. I think that the language was pretty specific that you could do that. But if you weren't going to get forgiveness, I don't know why you would. So, I'm sure there's going to be some sort of communication that's going to come out from your original lender, probably something in the form, because we haven't talked to the bank yet about this, but, probably you'll get some form of a let us know what your intention is type of request, or they'll just say, hey, based on the new guidance, you can either do this or that. But in this specific case, it just sounds like, why would you apply? Because you've now got, once the law gets signed, once the bill gets signed into law, you now have an extension of time. The couple things that we didn't touch on that the bill did not include, anything about the deductibility of the expenses that you're applying for forgiveness on. So the expenses are still taxable as of this iteration. You do get an extension of the payroll tax deferral to the end of the year, which is great. That'll help people out from a cash flow perspective, but you don't get the deductibility of expenses. The second is it was silent on any modification to the max payroll coverage. So I think my assumption and what I've been advising clients pending further guidance is that you're probably still going to get stuck with that 15,385 cap, because they gave you flexibility on the FTE count. So I don't think it's going to be a scenario where they say, hey, you can spend, if you're only able to cover 15,385, now you have $45,000 available for the same FTE. I doubt they're going to make that change. It's possible, but I would doubt they're going to make that change.
Next question is from Chris. Does the extended period match up with the determination of FTEs? Do you use weekly average hours during the extended period of time?
It didn't provide any modifications to how you calculate the FTEs from the original application. So I think you would assume that it's going to go based on the language of the original interpretation. The only thing that it did touch on is that your window of time expanded from June 30th to December 31st to do your best faith effort. Does that sound right, Jack?
Yeah, it does. And like I said, there's a lot of interpretation that needs to come down as to what is meant by that. There are, the little that I've found on this in the past 24 hours, there's a lot of speculation as to, okay, what does it mean? I'll throw out a statistic that I found that is, according to the National Federation of Independent Businesses, 23% of borrowing businesses will hit the 8-week deadline next week. So, it's questions about whether to zig or zag. There's a lot of things that we can't answer. And I will say that, what we talk about today, especially today, because this is just new and hasn't gone through the regulatory process for interpretation, there's a lot of, I hate to say more to come, as we were saying a couple weeks ago, but that's kind of where we're at in a lot of these. And so, please understand that we're not answering your questions because we don't want to. It's because we just don't know at this point.
Well, the reality what happened is that me and Jack lobbied our congressional legislators and said, purposely keep it vague because we really enjoy these Tuesdays and Thursdays together since we hadn't seen each other for a while prior to this. So thank you guys.
Yes.
Just kidding. And you don't need any more red shirts.
You're thinking out loud again, Adam.
Oh yeah, it's like quiet talk. Yeah, there's not vodka in this, I promise.
Oh man! All right, next question. if you could spend the entire amount of PPP loan in a total of 16 weeks, how will it show up on your books? It affects the balance sheet, but will also affect the income statement. Do we have to wait until we get forgiveness to show it on the books? Meaning it could be 2021 before we know if we have forgiveness, but it's 2020 that this is taking place.
Most of the stuff, from a book perspective, and then also, you probably, question on how you would treat it from a tax perspective. But from a book perspective, if I'm thinking through the financial statements, and my financial statement partners would probably slap me for saying this, but I don't think there's been any specific FASB or GAAP pronouncement around how to treat this. So it's a lot of speculation, but my assumption is for this purpose, you would go ahead and treat it, assuming that you had, a good, you had a good indication that it was going to be forgiven because you'd follow the rules, then I think you would go ahead and treat it as if it had been forgiven, even though you hadn't officially received forgiveness yet, and then do something in the disclosure statement, pretty similar to how the financial statements that we issued for 2019, the subsequent event footnotes indicated the amount of PPP loans that were provided to the client, and then also what the estimate of the forgiveness amount was going to be. I'm assuming you do the same thing here, because very similar within GAAP. If you, and this would cover Jack's area, so I didn't mean to bore you, Jack. But if you've got a pending lawsuit and the outcome is pretty damn clear about what's going to happen, then you can go ahead and disclose that and book the associated liability or the settlement amount if your attorney provides a letter saying it's pretty damn clear what's going to happen. So I don't see this behaving too much differently if you follow the rules.
All right, next question is from Chris. In determining FTEs, is there any relief for construction clients who could not pay people due to bad weather? In other words, they would have been paid or would have paid them 40 hours per week had the weather been better, or do they now have more time to get the averages up, assuming the weather cooperates?
Well, it's more time to get the averages up. I think with the weather, you're probably going to get stuck on that one, unless you could figure out a way to backdoor into times that you couldn't work due to health concerns. Jack, you got any thoughts on that one?
Yeah, I think, and again, this is a Jack theory, that the purpose of it, the interpretation is related to COVID-19, and you see various places in the regulations and the statute in the application form where it does link it to that there has to be a link to that, as well as, so for example, as far as employees saying, no, I'm not coming back to work, in some instances, it would be better that it's because they say it's related to COVID-19 or something along those lines that caused the problem, versus them saying, I got a better gig elsewhere, or remaining silent. And again, Jack theory, there's nowhere that I know that it says that, but just, that's reasonable to expect that it has to be related to the crisis.
Yeah, and I think, again, if you just play out the math on that one in the construction industry, you've got some bad weather, but you also have backlog, and now you got 3 times the time to deploy the money, and it was originally just a 2-month calculation. So, I don't think we've ever had a season that was that bad for anybody from a weather standpoint, where, you basically were behind 3 to 4 months and couldn't make it up, which would be the only situation I can think of that would apply here, where you just weren't going to be able to deploy the money. Now, if you didn't have the backlog, that kind of falls back into the original thing we said at the beginning of the webinar, which is if you've got problems deploying the money even in 24 weeks, look, I think you need to look at yourself in the mirror and do a gut check and say, do I have bigger issues that I need to look at? And somewhat related to that, again, we haven't talked to any bankers yet, but about the passage of this, but in getting prepped for the call, I did start to see some articles saying that, and this probably relates back to why a lot of our banking partners are going out to some of their bigger credit exposure clients right now, just to find out what their plans are. There's probably a good chance that credit's going to start getting pretty tight, because, okay, you got some money and that was a lifeline. But future lending decisions are going to be based on, you know, recovery, viability, economy, how you're performing otherwise. So I think you need to start thinking bunker mentality. You know, we're in, you know, even though we're not in a recession, we're in a recession from a lender's standpoint until, or at least assume that's what's going to happen, until you hear something differently. So from your bank.
Next up is from
And
Joe.
Gary, if I could, if I could maybe preemptively answer or respond to two things in relation to numerics, because I'm getting a lot of questions, you know, the what ifs before this was, you know, for a couple days ago and even through today. Two things, the $100,000 and the $15,000, does that somehow morph into something different? We don't know. As far as the, you know, so there's that. Also a subcomponent of that is the non-cash, the benefits that are now inclusive or included in this extended time period. What happens with that? So can
Ooh, that'd be
money
pretty
be
cool.
consumed? Right. So can money be consumed for that? So, you know, we just don't know. As far as now the math, it's, you know, multiplied by 2.5 is, or, you know, the math that associates with the usage of it. Does it somehow extend? So the math, I guess what I'm saying is the mathematics of it, the formulas of it that have gotten you to certain numbers with respect to employees and dollars and everything else. We just don't know yet how that is going to be changed. And so, you know, any questions that people have on the math, we just really don't know yet. And so I want to maybe knock out what is on a lot of people's minds on this call and otherwise.
Which means that we're probably going to be back on the air next week. Next question is from Joe.
Again, they kept us alive. Just need a good old fashioned tax law change with some litigation associated. Then we can keep the band together.
Oh yeah, they're not paying us enough for these broadcasts. We're gonna have to start selling some ad dollars. So here's from Joe.
Well, sign up for the Davidson on the Green run sometime later than 2012.
All right, there you go. We'll be looking for that check from them. Joe, are we now saying that if we meet the FTE count equivalent to match February 15 number, that you can take the loan based on 2.5 months of payroll and spend it over a 24-week period on qualified payroll and expenses, and it will be forgiven? 8-week use window is irrelevant.
That's what we're thinking now, but as Jack just said, we don't entirely know, but that's what we're thinking now.
All right, next question. If you terminate an employee with cause that reduces your FTE by 1, then we do not need to be concerned about replacing that position to protect our forgiveness, correct?
That's the way it reads now.
Carol, did the Senate clarify the $15,000 limit per employee with the new 24-week forgiveness period?
Since Jack just answered it, off to you, Jack.
Yes. So again, not yet, but they likely will have to choose their path one way or another and rebalance the numbers and the formulas. And Adam made a point that, you know, where they kind of have given on one side of the equation, they may not be giving on the other side of the equation and maybe only change one of the variables. So that's why, another reason why we just don't know yet.
Yeah, that's where I just to chime in. I mean, I have a hard time believing that, you know, they're going to say, hey, because if they gave you $45,000 instead of 15, that sort of defeats the purpose of hiring people back and getting them off unemployment.
In a related math question, this is from Scott. For new PPP applicants, will this increase their potential loan amount, i.e. total payroll divided by 12 times 6 or 6.5 versus 2.5?
I don't think that's going to change. There was nothing in the law about that. And secondly, you know, Jack mentioned some of the concerns about the holdouts. You know, one of them, and I can't remember if it said this or not, Jack, but I think one of them was Ron Johnson, which I can't remember where he's from. Maybe it's Minnesota. But his specific concern was the ability to reapply after you'd already received one loan. And they said, no, that's not the case here. So they could recharge the funds for people that haven't received them yet, but it's, you know, the way it's reading now, it's one loan, you know, period. Which kind of gets back to, if you weren't going to be able to use it, maybe you got bigger challenges that you need to just be honest with yourself about.
Few questions here from David. Good to see you here, David. First question, can people who spend all the monies and be ready to submit forgiveness after the original 8 weeks, can they go ahead and submit forgiveness now at the end of the 8-week period per the original agreement? That's question one. Two, do they have to wait 24 weeks or to submit for forgiveness, or can they submit forgiveness, say at 10 weeks, if they're fully spent and ready by then? Does the June 30 rehire exemption now become a December 31 rehire exemption, meaning you can get 100% forgiveness as long as you get back to baseline FTE?
I'll address the first question, Jack. If you can take the other questions if you remember them.
Sure.
We always get Gary to reread. Yeah. You can theoretically apply for forgiveness under the original timeline, but I think Jack's advice from the other webinar was really, or the previous webinar on Tuesday was really good, which is, you know, there's no downside to waiting a couple weeks. You know, if your clock was about to expire, as Jack pointed out at the start of this time period, and you otherwise have a green light, all systems go, everything looks like it's lining up right, you're going to get 100% forgiveness. Yeah, I'm in the camp of get it done and out of the way before they change anything else that might work against me. But at the same time, there's not a downside just to waiting a couple weeks, just to let things shake out. You know, and the first date you can apply is the first date that the bank will accept your application. So it's really going to be up to them to say, hey, we're ready for you now.
Do you remember those questions, or you need me to reread them?
I think I remember. So it has to, the question relating to, do you have to wait the 24 weeks?
Yeah.
My understanding is the answer to that is still no. So if you've done everything you need to do and you've spent all the money properly, then you would think, okay, go ahead and get it in the queue for forgiveness. As far as the rehiring exemption, the date has been moved out to December 31st. What I don't know is that, you know, it's in some things that I've read, it is that the rehiring may not be as important, or there may be, maybe some refinement as to the cause of the lack of rehire or something along those lines. So I think there's going to be further interpretation as to what that means, and potentially, you know, it's there has to be a deadline, but we don't know yet if what the impact on the rehire regime, the rules for that are going to be yet.
Yeah, I think, you know, so if I'm thinking out loud, you know, if you played out the math, for example, I'm a restaurant, I got, you know, 2 months worth of payroll, but now I have effectively 6 months to deploy it. Okay, I'm operating at 50% capacity by state guidelines. So you know, by default, I don't need as many servers. I probably don't need as much kitchen staff. So I'm gonna have trouble hitting my FTE count. Check. I can't rehire people. That's a reason why I can still say I get a pass, because I couldn't rehire people because I'm only operating at 50% capacity. Thus, my revenues would probably already be down. But you still have, you know, 3 times the amount of time to spend the payroll. So you got 3 months to spend. Did I get that right? 8 weeks, 24 weeks. So you got 6 months to spend 2 months worth of payroll effectively. So that's why I'm hitting for the guidance. That's why I'm thinking that you should be able to hit this.
All right, this is from Joe regarding the $100,000 income limit, does this mean that no single payroll can exceed 15,385 because it would annualize to more than 100,000? Or does it simply mean I can't pay somebody more than 15,385 over the 18 or the 8-week use window? And how does the 24-week window affect this $100,000 limit?
Well, all this crap may change. Amen for not swearing. So, the way that it read, so, right now I don't think the 15,385 is really going to change, but it may, based on the 24-week period. I just think that right now it's probably going to be that you've got 24 weeks to spend 15,385 instead of 8. The way the application read for forgiveness is that you needed to report everybody that had made over $100,000 from your original application that was still a body on your payroll. And everybody that exceeded the 15,385 number, that's off the top of my head, I believe. So what that implies, again, when I want to testify in court on this or not, I wouldn't. But what that implies is, the max you can pay somebody is 15,385. But if they're on pace to make 200 grand for the year, it doesn't matter. And your bad fact would be if they'd already made 100 grand up until that point. But again, when I want to testify in court on that, I don't think so. But right now it just reads 15,385, and then you got to disclose who all made over 100 from that calculation. Meaning, like, if you made, keep it simple, 16,385 in that 8-week period, you would disclose that and just remove 1,000 from your calculation. Again, on the caveat that all of this could change, in 24 to 48 hours.
Yeah, I agree with that in the sense that I think the limit, the core limit was the 100, and then it's just math dividing it over the period of time. And so you have situations where there's partial employment, partial unemployment, but unless you had a crystal ball, you didn't know how that was going to play out at the time you applied for the funds based on your employee count multiplied by the factoring percentage. So, it's I think that again, focusing on the $100,000 and paying someone more than you can't pay someone more than 15,385. I think all that is still stays constant, but it also addresses money that is in the pot that maybe you haven't consumed, but you cannot pay to that person. You can use it for another person or somebody else. But so it's the focus is per person to make sure, and we've mentioned this before, is that the higher paid individuals do not disproportionately benefit from this fund that was created for the broad range, the broad spectrum of employees at all different wage levels.
Next question's from Amy. We have fuel tanks for our company. Our fuel company monitors and fills our tanks as needed. Would this be considered transportation costs for forgiveness?
Goes back in that middle bucket of, probably, we'll say maybe it will. And again, just a reminder for everybody on the call, auto expenses as a utility were included in the sole proprietor guidance, which is meant to be an extremely small business where a car would be a necessary utility in what I do. So it's somebody who files a Schedule C on their tax return, which, in BGW land is going to be, somebody probably, we've got a couple clients that are large that are on a Schedule C for reasons that they're still electing to be. But for the most part, you're talking about businesses, 300 grand or below in gross receipts. That's where all the auto expenses were covered. Thus far, it's been silent on the inclusion of those on the regular, when I say regular businesses, the C corporations, S corporations, LLCs, taxes, partnerships. And in fact, it did not include it in the application for forgiveness when it talked about eligible utilities. So they had an opportunity at that point to say, these are examples of eligible utilities and include auto and transportation, and they did not. included in the original application. So I think the original application for forgiveness, which covers S corporations, LLCs, taxes, partnerships, and C corporations. Sole proprietorships is still supposed to come out as a form. And again, it goes back to, well, now your ratios have all changed, and at the same time, you have a broader window. So I think original guidance still stands, which is try to get there on payroll, and the exact definition of rent and utilities without trying to swing for the fences on this one. All that said, it was the auto manufacturing lobby that really pushed for the 60-40 split. But at the same time, large manufacturing facilities, I mean, they might have some fuel costs, but their utility bills are exorbitant. If you just think about the assembly line. So I'm thinking that's probably, why they were pushing it. So much automation, but a lot of juice hit into the system.
So here's the next question. I worked for a restaurant that received PPP loan. They were paying us an estimation of our tips and wages while we were still closed, 2 biweekly payments. But we've since returned to working. The restaurant is now crediting our tips against what we will receive in our next 2 biweekly payments. I did some research, and it seems there's a safe harbor clause that allows them to supplement just the difference between what you made in tips and what they originally allotted for each server. Is that accurate?
There wasn't any specific guidance in anything from any authoritative source, which the only 2 authoritative sources are the Treasury. The law is the most authoritative source. It wasn't there. The second most authoritative source is the Treasury. Third most authoritative source is the IRS. I don't recall seeing anything on tipped employees or even commission-based employees, other than it said you could go ahead and pay them an amount, to be determined, of your determination. So the advice that we gave to our clients was you probably ought to at least get to minimum wage, since that's already the established basis for the FICA tip credit, which restaurants qualify for. I haven't heard of anybody that said, hey, I went ahead and paid you while you were gone, and now I'm going to take back tips from you, which sounds like is in this case. So, Jack, have you heard anything?
Yeah, I think I have not, and agree that there's not a whole lot in there about variable compensation like tips. And it's a difficult thing because, while you have minimum wages, it's okay, what is the reality of getting tips? Because of the fact that people have less disposable income, maybe are a little less generous, whatever it may be. So I don't know. I don't have an answer for that question. But I think that it's one of those that impacts a lot of businesses, a lot of hospitality clients. And so I think that will, again, need to be interpreted with respect to the forgiveness aspects of having paid that out at the proper amount, whatever that may end up being.
All right, next question. You may have touched on this in some previous sessions, but what are your thoughts on how payments to temp agencies would be handled, i.e. costs for temporary workers contracted from an agency like Robert Half, et cetera? It would seem clear that this should be included in payroll costs for purposes of qualifying for loan forgiveness. Do you agree?
No, it depended on the nature of the contract. So, temp to perm, whether you're an employee and Robert Half just has a replacement type contract with you, you're probably okay there because they were on your payroll and on your benefits at some point. Straight up contract labor, you're out on, because companies like Robert Half could apply to cover that same person. I mean, Robert Half couldn't probably because they were over the eligible FTE count, but we did have a lot of staffing companies that were below that number that did apply because, the position was, we're the employer. So it would depend on who the employer was. In the case of straight up contract labor, that you were using to replace a regular W-2 employee, I think you're out on.
And a caveat to that, or additional suggestion, is if you're using contract labor, reach out to the company that you're using and get their perspective. You know, did they apply? And see if that doesn't answer the question, but it invites communication as to what they did and how they are treating potentially your contract employee.
Yeah, and I think that I just saw the comment from Robert. I think the challenge that you get into with all things, you know, having not written the line, just encourage them to make it as confusing as possible so Jack and I continue on and I can make Star Wars and Star Trek references. You know, at the end of the day, whether you're right or wrong doesn't matter. It's what the bank will accept. And if the bank says, hey, you didn't get to include independent contractors on the way in, we're not going to let you include them on the way out, you're stuck with whatever they're going to take, despite your argument to the contrary. I hate following rules too. It's been one of the hardest lessons that I've learned.
Next question. We received PPP loan amount on 5/11. Assume it's 8 weeks. When should we apply for forgiveness? Bank said should be right after the 8-week period on 7/6. Is that correct?
I think it all changed. It all changes based on this law being signed. So I'd hold off for a bit.
This is from Paula. Are the dates for returning the forgiveness loan application either 56 days post receipt of PPP or December 31st? We have not lost any FTEs. Can you submit forgiveness application at any point between June and December?
You want to hit that one, Jack?
Yeah, I think we need to be careful on until we know more, because what I've been reading is a little bit inconsistent. So you have on the one hand, you know, according to, and I don't have the application in front of me, by my recollection, it was October 31st. It says, you know, forgiveness application needs to be submitted. And then there's this discussion about applying within 10 months after the end of the cover period, or you have to start making loan payments. And then you have the issues of the extended cover period. So all that logically makes sense, except for the part that, does the extension beyond October 31st apply to just the loans that were originated, or the loan funds that were received, or the loan funds that were used, and we just don't know, after this Flexibility Act gets passed, which it hasn't gotten passed yet, unless it's happened in the last 47, 48 minutes, unbeknownst to the three of us on the call. So those are the things you need to think about. You know, as far as applying, it goes back to if you're in the money, so to speak, that you've used the money, you've done everything you were supposed to do. There's no real opportunity for you to do more, because there is no more. Then maybe go ahead and seek the forgiveness, but it's on a case-by-case basis. But as far as the extension to you know, the 10 months to apply for forgiveness application, well, first of all, you shouldn't do it before the end of the use period, because you just don't know if you've qualified for it. And also, you don't know if, you know, okay, for example, the rules changed to 60%. So if you have, and this is pretty consistent with what we've been saying in prior discussions, which is if you have a little bit more time, then maybe you should take it just to see what else comes down the pike. And that includes or means interpretation by Treasury, interpretation by the SBA, not just after the president signs it, hopefully very soon.
Okay, gentlemen, we are entering the lightning round. We have 10 minutes left, and so we've got
Got my buzzer. Just kidding.
So here we go.
You know what we need to do? We need to get, what we should do, there's probably an iPhone app for that. So we're going to figure that out before the next call and figure out how to buzzer in on the answer. And then Gary, you'll be the judge on that.
Okay. So next question, just to clarify, right now the thinking is that the max amount for wages for employees is still $15,000, not an expanded amount to reflect 24 weeks.
Yeah, I mean, I wouldn't bet on it being expanded.
Next one's up from David. What about, so question about what Adam just said regarding upper end pay cap. Is there a cap of 15,000 and change that anybody can be paid during the 24-week period. I think we just answered that. From Neil, hello. Do uniform costs count towards PPP funds?
I wouldn't count on that one either.
This is from Chris. Just a follow-up. I'm not sure what your answer was, Adam. Do you mean that you still look at the 8 weeks for the FTE count?
I don't think it's probably going to matter whether it's 8 or 24 weeks, and I'll ask Jack to hop in here. I think it's going to be 15,380. You said, was that salary or FTE count?
It was FTE.
Oh, FTE count, it's still going to be an average. Well, actually, I don't know, because since you got the expansion of the 24 weeks, I think the way that it's probably going to read is that it's going to ask you for the average of the 24 weeks, but then the safe harbor will move from 6/30 to December 31st.
Yeah, I think there are mathematical challenges embedded in there. So because I think there's a dilutive effect if you expand the 8 weeks, if you expand the FTE count, and then you're using money, and then we're talking about averages. So, and I haven't worked all that math out, but I think that there are potentially unintended consequences because they didn't go through all of the mathematician problems with, what is the effect, the ripple effect of moving certain milestones and marks, for whether it's date, FTE count, or money. So I think we don't know yet, but there's going to have to be clarification, because there's going to have to be submissions on paper with numbers and inputted into formulas. So I think that's one of those wait to be seen issues.
Next question is from Joe. What window does FICA deferral option apply to? June 30 or 8 weeks from the funding date, or now 24 weeks from the funding date?
I think it went through the December 31st. It'll be on our explainer that came out, because I think Blaine addressed that in the commentary, but I think it actually expanded to the end of the year, which I believe was the original time frame in the CARES Act. And the only carve out was if you received funds, you couldn't do it anymore once you receive forgiveness, but now you can. So I believe it's December 31st.
I think that's probably accurate, and I don't have it in front of me, but if you think about what they're trying to do is to put more cash into your company coffers. And so if they can do something that isn't necessarily costing them an output of money, meaning having you keep that money that you would always have an obligation to pay on the employer side, seems to make sense, and they would extend it. But I'm, like you, Adam, I'm not sure at this point. I don't have that in front of me if that is in fact the case. But yeah, there'll be clarifications on that, definitely.
Yeah, and just the caveat on that too, for anybody, because we did that ourselves at BGW because it was available, so why not? It was a source of cash, just in case. But the caveat on that is, I believe 50% of that is still due December 31st. So if you get into kind of this, wahoo, moment, I believe you still got to stroke a fairly substantial check December 31st of this year. And I'm sure Blaine will have corrected me if I'm wrong on that, but I believe it's, so don't, it's good, but don't, otherwise not have the money on deck in reserve, because, as we tell people often, while it is a good interest rate, you really want the creditor of last resort to be the IRS.
Yeah, and
so places where companies go before they die, factoring, then the IRS.
Right, and the word that is consistently used is defer, or a derivative of that, deferral, deferred. So that unless they've changed the definition to mean forgiven, that means what it means, which is punting it down the road to another time.
Next up is from Robert. Will the Fed Main Street lending program rollout be delayed now that the PPP end date has been extended?
I don't think so, because it was really geared towards two different classes of companies. The Main Street lending program was really geared towards companies that still needed some credit assistance that otherwise were not going to qualify for PPP funding because of their size, average FTE count, affiliation rules or whatever.
Yeah, that logic makes sense, that it's two different constituencies for the programs, but surely there's going to be clarification of that in case, at the fringes where there might be some crossover potentially. But yeah, that's people have been focused on the PPP side of things, and so more on Main Street likely to come.
Yeah, and for folks that are on the call, if we have any bankers, or anybody that's actually spoken to their bank about the Main Street lending program, please shoot us something to faq@trustpgw.com or the chat, because we haven't, I'm not aware of any clients that we have that have even, well, I'm 99.999% confident we don't have anybody that's received funds, because I don't think the application's even been available to apply yet. But I could be mistaken on that. But that is supposed to go through your banking platform. So I have wondered what's the holdup on that. Is it the bank? Is it Treasury? So it would be good to hear from somebody that has more direct knowledge of exactly what the process is going to look like for that.
Next question. Now, may we use our semi-monthly payroll numbers times 4 pay periods for our hourly and salary employees without making any adjustments to payroll?
I don't know if you had too many differences other than now you just have 24 weeks to deploy the money. I mean, it's still, well, sorry, that's going to be Jack's diluted question, which is stay tuned on that one.
All right. Well, you guys have done an excellent job. We got 3 minutes left. If there's any other questions, hit us now. And I just got alert that's really important. Lenny Boy is just about 20 minutes away from delivering my next batch of kombucha. So I'm really excited about that because I'm dry. So any other
Clean Juice guys are going to give you hell on that one, Gary.
I know. I'm going to hear it from Clean Juice, but I spent a lot of money with them yesterday. It was really good.
So for those of you who need a, Cliff Clavin moment, for those of you who know who Cliff Clavin is.
Oh, yeah.
Had to get a Cheers reference in.
See, there you go. I'm up in my game. Senator Johnson is a Republican from Wisconsin. So I just found that in my notes.
Oh, got it. Okay. Yeah. So it was not Minnesota. Good job. I should have known that. He's kind of, oh, never mind. I won't get on that soapbox.
All right. Well, everybody, thank you for joining us. This was excellent. You guys did a great job. We finished 2 minutes ahead of time and got a lot of stuff in. So everybody, if you had to join late and you want to see the front end of this thing, we'll actually have a link to the YouTube, I think, in this email that'll go out to everybody that does have this more detailed explainer of what happened in the Senate bill. That'll be coming from Rachel Cofftree today. If for some reason you don't get it by the end of the day, email me at gfrey@trustbgw, and I'll make sure that we get it to you. Again, gfrey@trustbgw. And we will have this thing up on the BGW YouTube site, BGW CPA YouTube site later on this afternoon. So
yeah, I think I saw some. Sorry, I was also going to say I think I saw some traffic as I was looking for this meeting link to join Gary. That it's also up on our website under our blog, meaning the breakdown of what changed. All
right, great. Jack, thanks for taking time out of your day again to join us. It's always helpful having you on, and we celebrate with your son on his graduation. So have fun.
Made it out.
Exactly.
Yeah. Yeah.
All right, we are adjourned. Have a great day.
All right, see you guys. Thank you.
See ya.
All right.